Welcome back to the Mortgage Law Today webcast, web show, whatever we call it. I'm still struggling to figure that out. Um,
I
again,
think we could add extravaganza to the title.
extravaganza.
There you
Well,
go.
we're reporting from the MBA annual conference in Las Vegas, and we're all still recovering from the Pink concert last night, except for poor Loretta, who didn't get to go, but she's apparently, you know, she's so close with Pink already. She's seen her many times, and they text each other all the time. Anyway, we are very fortunate today to be joined by two wonderful guests and then our two regular hosts. Our guests are Michelle Rogers from Cooley, partner at Cooley. Michelle, what is your title at Cooley? Or do you?
I'm the global chair of the financial services group at Cooley.
Yeah, that sounds really important.
Best
Congratulations with
title ever.
that.
Yeah.
And
Thanks,
we also have Melissa Koupal, who is, I guess, fairly recently with CMG. And what is your title, Melissa?
Well, hello everyone. I'm EVP of Risk and Compliance at CMJ.
That also sounds important. So
It
welcome
does,
aboard.
doesn't it?
No,
Lots of
but
Your
letters.
3 hats. Tell us your other hats, Melissa.
yeah,
Like,
I was just
what
going to
you
ask
get
about
to brag
that.
on.
All right. So then I'm also chair of the Industry Advisory Committee for Armor. And then also serve on ResBog for MBA, and then also own the infamous RegList as well.
Well, we'll talk a little bit more about that because I'm fascinated by RegList. I think it's a great thing that you've been. How long have you been doing RegList, by the way?
So I always think of my oldest son, so because that's the age, and so we're approaching 19 years. Crazy.
Wow,
So yeah,
that's
19
that's
glorious
just
years.
unbelievable. Of course, we're also joined by our regulars, Loretta Salzano and Peter Idziak from uh, our wonderful hosts, Polunsky, Beitel, and Green, our sponsors, I should say. We're the hosts. Anyway, um, why don't we get going this week? You know, I'm not hearing a lot of legal issues, although we do have, some things that we're seeing in the press recently. But mostly what we're seeing is a lot of discussion about state issues, state regulatory issues, state enforcement issues. And I thought maybe we would start with that topic. There was a great panel that Michelle was on at the regulatory conference last month, with a bunch of regulators. And I thought maybe, Michelle, give us a little bit of the lay of the land in terms of what you're seeing that, now with the CFPB sort of, whatever we want to call it, decimated, I think is an accurate mathematical description, if you take away 90% of the staff. So, what are you seeing at the states? What are some of the sort of I would say, step up issues that the states are doing now that you weren't seeing before?
Yeah, absolutely. So first, I will say, as far as the CFPB goes, we've settled now, I believe, the last lawsuit that the CFPB was litigating. I think that's it now. And we noticed last week to the judge that we had reached a settlement in principle. So just for what it's worth for your listeners, with that off their docket, right? There's a big question about what happens next. Of course, we want staffers at the CFPB to work on rules. You can't change a rule or undo a rule without a person to write a rule. So our hope is that I think collectively, if we want to get RESPA, if we want to get LO comp, that we see not a full decimation, if you will, Brian.
Well,
But it's also,
I mean, I did hear there's like still 50 enforcement attorneys working there. I mean, they're not like, tapping their pencils on the desk, I think.
I'm pretty sure they were all on the phone call on our one matter, and I've never had that many on a call. But look, there's a lot of really good people over there who are very committed to the mission. But it's relevant, and it's a good transition back to your question because there's a lot of them who are leaving, and they're leaving to do other things. Some of them are leaving to go into plaintiffs' firms. Some of them are leaving to go in-house. But one place that they are going are the states. And the states have been very actively recruiting from the CFPB. New York in particular has been on a hiring spree. And one pattern you have seen there is in cases where the CFPB has put things down, the states have picked things up, including in one instance, a case where the CFPB lawyer left went back to his home state of New York, where he is now on the state case that they are litigating. So, you will continue to see really an increase both in sort of the tactics that we've seen at the CFPB, I think, some good, some bad. Certainly the knowledge is helpful. I won't lie. There are instances where when you are dealing with the states, as wonderful as they are, trying to understand a federal regulation, you really do sometimes wish that you had the policymakers and the experts from the Bureau in the room, because it can be really hard explaining the nuances there. But what that means as a practical matter, Brian, is we are seeing an uptick from the states, both at an exam level and at an enforcement level. What is different, and what I think you're going to see more of, is an appetite to push back. And I think a part of that, if you go to the psychology of it, is probably because we've all lived with, particularly over the last 4 years of the Biden administration, a very aggressive CFPB where folks in our industry and others just felt they weren't being treated fairly, and really started to lean into the idea of maybe we need to get in front of a neutral arbiter, meaning a federal judge. And as states now start to adopt some really aggressive theories, our clients are really considering, maybe we need to go to court. But state court is very different, and litigating with state agencies is very different, and that introduces some complexities. So we're really seeing a fast unfolding of unique issues, not always just state level, but what I think are going to influence some of the litigation culture in our industry and some of the discussions that are happening.
I want to come back to a bunch of the things you talked about there, but one of the things,
Right, me too.
yeah, I know, right? One of the things you just said made me think about something. What is the impact of sort of the Loper-Bright decision on state law interpretations? Has there been any? Does that sort of change the dynamic in those discussions?
Yeah, not necessarily, right? I mean, Loper-Bright, of course, goes to the deference given to administrative decisions versus what a court can do on the basis of the plain language of the law. But there are other decisions that have been less widely recognized that have very significant implications for some of these state issues, one of which being Jarkizi, which was a case involving the SEC administrative law judges. And as we, coming back to the point I was making, start to think about, look, are we going to litigate with a state? That can actually be really meaningful, because there are real due process implications depending on the way the state agency is structured and the way the litigation is set up, to whether in fact it's appropriate, for an example, for an ALJ to do something more than injunctive relief. Can they issue penalties? There's a really complex issues when you're dealing with the states that are just different than federal law. For example, in some states, the attorneys general do not have statute of limitations applicable to their consumer protection laws. In some states, they do. In some states, they would have them if they prosecuted them through the AG, but not if they prosecuted them through the agency. But if you go through the agency, there might be different administrative remedies, which comes back to my point. And I think I've said this, maybe not at the last MBA meeting, but the one before it. It's really, really, really important to work with counsel who know, and it doesn't have to be me. I'd love it to be me, but it doesn't have to be. To work with counsel who know the state, because every state is a little bit different. The culture is different, but the law is different. And that means what you do strategically is really going to depend on a nuanced understanding of how those cases are tried.
And relationships, always key, right? Always key. And I think that's the
100%.
case whether it's examination or enforcement. And that's one of the things I wanted to ask you about. If there's this influx, and we've seen a recruiting effort where folks at the CFPB are leaving to go all kinds of places, including to states. Some of them are probably going to more enforcement places or AGs. Others are going to regulatory bodies where there might be supervision and examination. So could you talk a little bit about how you're seeing these ardent consumer advocates from the CFPB their impact on the states, because I know that there was a lot of frustration, I think relatively recently, from some of the more zealous consumer advocates at the CFPB, where they felt like they weren't getting the attention or resources they needed to bring certain types of actions. And now that they have a different audience or different funding or different leadership, how is that shaping what they're doing in these various roles?
Yeah, that's a great question, Loretta. I would say a couple of things. First, look, the federal budget, typically outside of the circumstances we're in now, is going to give them more resources, more time, more money, more effort. So it is easier, generally speaking, for them to bring a big federal case, from a federal position. The states, while they have authority under the CFPA, they typically don't do that unless like the wheels are coming off the bus, everyone hates each other, it's the end of a multi-year investigation, and there's a lot of chest thumping happening. Usually the investigations are going to start at the state level, unless, and this is particularly true in examination context, but it happens in enforcement, if you're dealing with a multi-state. So keep in mind, the way states pursue matters, there's a couple of ways. One, certainly coming out of exams, just like at the CFPB. Two is, independently initiated because somebody gets something in the mail, somebody sees something, or just like the CFPB. And then they can either bring it themselves on behalf of the state, of the people of the state that they serve, or you can see a coalition come together, which is a multi-state. And typically in a multi-state, and I have one now that has many, many, many states involved, and another one that's maybe a little bit smaller, but still significant. You'll have a couple of states that are like the executive committee, if you will. They're running the show, they're interacting with council, and then they're going back to report to the states. That's still more manageable in that, you're dealing with certain people, but the problem is then I'm filtered through 2, 3 people rather than talking directly to the individuals in those other states. And that can be really challenging, especially when you feel like your message isn't getting through, that these people may not understand it or understand the nuance. The other way is you can also, and I speak from my position as also the co-head of the firm's state AG practice group. So I spend a lot of time with the attorneys general. I know Loretta's like, it's like what, she's a glutton for punishment.
Well, I'm a lover, not a fighter, girl. I admire you.
I know you are. She said that every time I try to send her something, she'll be like, but Michelle, just remember, I'm a lover, not a fighter. So the other thing is they can also just do it all at once. And we do have matters at the firm where we have 40 individual state investigations. And at that point, you're like praying for a Fed or praying for a coordinated effort, right? Because remember, those state laws are going to be different unless we're talking about general UDAP, which are still similar principles, but not always the same law. You're going to be dealing with a collection of different states, which leads sort of to maybe some of what we started at, with how the states maybe aren't really understanding how privilege works in this context because they're trying to adopt federal standards without realizing that it doesn't translate one for one.
Well, let's come back
That
to
might
that
be
issue.
a good place for Melissa, right? To jump in on the MMCs.
Well, yeah, I was just going to ask, A, what Melissa, what are you seeing? And sort of B, how are you responding to some of these things that Michelle's talking about?
Well, I mean, it's hard. Michelle deals with an array of different scenarios. She has a lot of various fun. We'll call it Michelle because she does enjoy it. But I think, I'll say one thing today is we just had, notice from a state that they're going to leverage an exam that was done through the SES. And so I know that's a little bit of the polar opposite was what Michelle's working through. But I think it's also something that we're seeing out in the industry is some of the positives of some of the states working together and being able to leverage exams as well, which can also be scary because they are looking at your exams and seeing the issues that come out, but seeing a sense of relief of, a company such as us at CMG, where we're licensed across the country and the territories and the number of state exams that do come our way, and to be able to have some is nice to see. So
So,
And
Michelle,
I'll
you were
just say it, if I could, Melissa is the poster child for build great relationships with the states because it goes a really, really long way. And I know, and I might make her blush, but she's spent every moment of those 19 years at RegList Plus working really hard to do that. And you don't want me in the room. If I'm in the room, things aren't going well. You want to be sort of doing what you can to build those relationships.
100%. I think it's so important to invest ahead of time. Don't wait until they show up, right? To give you an exam and sit across from you. The idea is to get in ahead of time. And I think like we see at the Armor conference where the states want to engage with you. They want to talk to you. They want to talk about the trends that they're seeing and things that can improve upon. And so build those relationships by going and interacting at NMLS, at the Armor conference. And even, just calling and picking up the phone and saying, hey, I got a question about this or that. So it does go a long way. 100%.
You do have to be a little careful about those questions. So if you don't already have the relationship, because you might get a knock on your door because you asked the wrong question or said the wrong thing.
Well, you just say, I'm asking for a friend.
Yeah. Or you just say, you have your counsel
exactly.
you have your
We can
counsel
do
ask
that.
on a
We
blind
can do
basis.
that.
That's when you call. Yeah,
Yeah.
that's when you call
friend.
counsel and say on a no
Yeah, on a blind basis.
On a no
Yeah.
names
Call.
basis. Yep.
Or you disguise your voice and you call from your kid's number, right?
Well, so this is kind of a good segue into this topic of privilege and confidentiality concerns, which I think there's sort of we've got, Michelle, maybe you can explain the sort of the privilege issue, the distinction between the federal and the state standards that you sometimes have to be aware of. And then Melissa, I'd like you to talk a little bit about reg lists and sort of the same kinds of issues. Not, like, how private are those discussion on reg lists that, sometimes I've seen some things on there that I go, oh gosh, I wish you hadn't, sent that out to the world that way.
Sure. So
So I
I'll
don't know where you
start
guys
with
want to go with that.
yeah. I mean, do you want to start with the privacy, Melissa, and then I'll translate over to the privilege?
Yeah, I think it's an interesting aspect of the RegList, right? So for those that don't know, if you RegList, RegLast, sometimes I kind of slur it, but .org, and you can, there's members, we got about 2,000 across the industry focused on mortgage compliance.
Don't forget to plug your conference.
Oh yeah, well, they'll see it when they go to it. Yeah, we got the RegList works November 4th through 5th in gorgeous Huntington Beach. So come join. I promise it's not all about s'mores. It's also about learning about the mortgage industry. But so one thing is there's about 2,000 of us on there, and Brian and I were chatting yesterday. And he's like, yeah, people put stuff out there and there's regulators and this and that. I said, well, I vet all the people that do join. So I always try to make sure, and we do have regulators that want to join. Hawaii recently, that was like, oh, I heard about it. I wanted to learn more. And I'm becoming, just getting into the industry. I was like, yeah, so it's just industry that plays in this sandbox. So we try to keep it. But the problem on that is that I think that's why we have anonymous posts, right? So some people will have scenarios that they want to have questions to, and I say, okay, well, you can send it to me anonymously, so then I can post it, and then you're not associating your company with it. But are situations where people will be a little bit more lax and they post it, and it's a listserv, right? So you email, and 2,000 of your closest friends just found out that you're having an issue in XYZ state or with this investor, or you have this fraud case or whatever it is. So we do try when people join to let them know that anything you put out there is, and you can't pull it back. So it's not one of those, oh, I'll just delete my post. It goes out to everyone. So there's a definite dynamic there, Brian, but it's something that we try to also disclose up front to make sure too that it's a community, but you also have to understand that you're putting it out there for public knowledge.
Right.
I
just think it's
have
important that people
secondhand
understand that.
anxiety. Sorry, Brian.
I know, Michelle. I know.
It just makes me clench every time. So look, first of all, that's not privileged. right? Because you're not talking to a lawyer necessarily. You might be, but you're not talking one-on-one. You're sharing that with a bunch of other people. So if you think you're getting legal advice, you might be, but just be careful because you're not in a privileged way. And look, it's a hugely valuable resource, particularly for some of the smaller institutions that can really gut check. I do a lot of that work on the phone with clients and I'm not free. So being able to go to that resource is hugely positive.
And not everyone on the reg list though is you. Come on,
I'll take it. I'll take it.
just saying.
You do get what you pay for, right?
Sometimes you get what you pay for, right?
Appreciate it.
Trust but verify. RegList is
That's
trust
it.
Right.
but
That's a great
verify.
way to think of
Michelle
it.
is
But
trust.
sometimes you're not
Yeah.
looking for legal advice. You just need color, right? You need color, you
100%.
need personality, and the reg list is awesome for that.
Yep.
Well, thank you.
Yep. Fantastic. And kudos to Melissa for how hard she's worked to grow it and get it to where it is today.
And that conference is the bomb. I can tell any of you. It's especially interactive. It's not just sit, and listen to lectures. It's very hands-on. It's almost like working sessions, and it's in a spectacularly beautiful location. And you get to be with Melissa.
There you go.
Yeah.
There you go.
Well, I'll take the plug. It's a workshop, right? So it's, there are sessions where you step into it, as I like to say. You put your hands on the issues, you talk about the issues, and hopefully you walk away with 50 new closest friends to network and be able to maybe not post on the reg list, but call up directly and ask a question.
So, Michelle, I don't know if you had a chance to really explain that the privilege issue when you're dealing with the regulator, state
Yep.
regulator, as opposed to when you're dealing with the CFPB or a federal regulator.
Yep.
Which I think is
So,
important. That was an issue that I was like, wow, I hadn't really considered that, and I thought it was really important to
and
bring it
it
up.
takes some intestinal fortitude. Because if you have a regulator on the other side yelling at you that you're wrong, you have to really feel confident that you're
Well,
not.
back up a little bit and explain the federal
You got
situation.
it. So under the federal law, 12 USC 1828X for the nerds in the room, it is,
That's all of us, by the way.
yeah, right. Your sharing information with your regulator expressly does not result in a waiver of the attorney-client privilege. That is codified. And so that the purpose of that, of course, is to allow the prudential bank regulators and the CFPB to be able to access certain privileged information in a supervisory context. And in fact, when the CFPB first came into existence, there was a big hullabaloo about the fact that it was not part of 1828X, that focused really on your primary prudentials, FDIC, OCC, Fed, and of course it was subsequently added for clarity. But that means in an exam context, look, there may be other reasons why I don't want to share privileged stuff with a regulator. There might be other workarounds, but there is not really a very strong argument, absent certain circumstances, and I'm speaking generically here, that sharing information with the regulator is going to waive privilege. That is not so at the state level. At the state level, most states do not have a codification that is similar to 12 USC 1828X that specifically says if you share information with us as your regulator, you are not waiving the attorney-client privilege. And so we've seen in exams recently a real effort and emphasis by the state regulators to say, well, give us your privilege information. And this is particularly true in cybersecurity events where they want to see reports, they want to see testing, they want to see, postmortems. But it's also particularly problematic in circumstances like this or other things where things come off the rails, right? Where there's a technology breakdown, where there's some issue that has an active consumer protection risk, and the state wants to see it. You have to say, listen, as much as I would love to give it to you, and the truth is, most of our clients would rather just share information with the regulator to demonstrate we're good actors, we're good citizens. Most of us are sophisticated enough not to write terrible memos that talk about where the bodies are buried. So often you're fighting about what's kind of a nothing burger in any event. But we have situations where the states are saying you have to give it to us. And we're trying to explain to them, if we give it to you, then we're going to have to give it to plaintiff's counsel or other parties, and we can't do that. And this materialized recently in a public action. It's a case involving Bayview, and we'll talk about that in a minute. I did not represent them in that matter, which is why I can talk about it. But in prepping for this panel at MBA, you know, I simply just raised it and I said, we need to fix this problem, guys. We have states saying we have to give you this stuff. And that's a safety and soundness issue. Because if I'm in the middle of a consumer protection problem, I know I'm going to get sued by, you know, 10 plaintiffs firms, and you're telling me I have to show you a report that I could otherwise describe or some other purpose, all you're doing is creating risk unnecessarily. And there's a misunderstanding at the state level because we do have regulators who go, well, wait a minute. What you share with us is confidential supervisory information and we won't disclose it. And the answer there is that's great. We trust that you won't disclose it. That is not our concern. The law does not say necessarily that simply because you promise to keep it a secret, I have not waived privilege, because the purpose of the attorney-client privilege, of course, is for me as counsel to be able to give my client legal advice in connection with potential litigation. It is not intended to share that advice with everyone else. And once you've done that, there is an issue of whether you've engaged in a selective waiver. So, you know, there's some Benson matters, most of them not public yet, where we've really had to go to the mat and explain to regulators that as much as we'd like to share information with them, doing so would create real risk. There's nothing there anyway. What do you want to talk about? Let's find another solution. But this Bayview case has really put a fine point on it, because there is a decision, it's a published court decision, that says, it goes into, you know, the judge was not going to disclose. In this case, it was a report involving, I believe, a cyber event, had previously ruled that plaintiff's counsel could not have access to the report. It was prepared by counsel, potentially in connection with litigation. Then the public settlement came out with the state regulators involving that matter, and it disclosed that the report had been shared with the regulators. Plaintiffs went back into court and said, Judge, what's going on? If other people have it, we should be allowed to have it. And the judge said, you're right, you should. And part of the rationale was it had been shared with the regulators. Part of the rationale is it had been prepared for the regulators, which undermines whether it's prepared in connection with litigation. But at the end of the day, that's a real risk and concern. And there's a lot of people in the market who just don't understand how privilege works. I can't tell you how often, and that's okay. You know, I want you to need me. I want you to need Loretta, and I want to be able to explain why, you know, we're nerding out, and Peter and others, right, on what privilege is. But how often do we get a copying Michelle on this email to make it privileged, and you are slow motion, like, oh, you know, because that's not what it takes, right?
Well,
Yeah. And Michelle, do these same concerns apply when it's an AG that you're providing information to at the state level, or is this like a regulator specific concern about the waiver of privilege?
Well, it's a different scenario, right? There is no preservation of privilege in the enforcement context. I mean, the same is true candidly with the CFPB and the CFPB supervisory context. They're entitled to privilege information. In the CFPB enforcement context, they are not, because they are not acting in a supervisory capacity. So typically when you're dealing with an attorney general, that is not in a supervision capacity, even if it's been referred to them. So you can claim privilege on those materials, and you're really not going to get in a fight with them about those issues. But it's the problem is at the supervisory level, the states who have been working for years with the feds go, wait a minute, you guys give this to the federal agencies all the time. What's the problem? And we're having to explain the problem is they have a statute that says we can do it. You don't.
yeah, I think this is a terrific issue for sort of sensitizing a lot of compliance people who interact with their state regulators all the time and would get a request in an exam for information and wouldn't even think twice about sharing information that they didn't really understand they shouldn't. And so I think it's really important that this issue gets elevated into people's consciousness, that you take a beat and you think, wait a minute, what's the situation? Maybe I better call Michelle or somebody and make sure this is okay to share. So
And
great,
look,
great topic.
there's always a risk reward calculus, Brian, right? Like there might be instances where It's my fair lending testing. Maybe I don't care. Maybe I do want them to be able to see it. Unless I've got 10 fair lending class actions right now, and then maybe I do care, and I'm going to think about the way I communicate that.
It's funny, but this issue first arose, sort of hit my radar way back in like 1994 when fair lending was just sort of becoming a big issue. And the whole issue was, should you do your fair lending analysis under attorney-client privilege to make sure that, it's protected? And, those discussions have sort of waned quite a bit. Everyone just does their own testing. But unless there's circumstance, I understand.
So
But sort
let
of
me,
everyone has a
But it's
compliance
true because
program.
there are
Okay?
regulatory
It's-
expectations that you're going to be performing testing more frequently, that you could engage counsel, just routine
Right.
looks.
but on that too, and it's a great example of what Peter just flagged. My fair lending testing needs to go to my regulators. If I get referred to the U.S. Department of Justice for a redlining investigation, I can claim privilege on that. So
Because you have the
but
statute.
only if it's no, actually, because I mean, if it's privileged, if a
Oh,
lawyer has been involved supervising
okay.
it, directing it, right? So
Right.
that's actually a reason why it can be useful to do that. But I don't want to end on doom and gloom. So one thing I'll just say is this: coming out of that panel, with gratitude to the state co-panelists who I maybe beat up a little bit in the prep session, and then who very kindly engaged on the stage about it. We've actually gotten really great engagement with them and CSBS in particular, who are looking into this issue. So my hope is, look, it's a battleship, not a speedboat, but my hope is that raising awareness of the issue will just help everyone, because it goes back to that regulatory relationship point. We don't want to fight with them if we don't have to, but helping them understand why it is we may not be able to give these materials is a critical piece of that.
Michelle, have you seen any regulators that have pushed back sort of under the argument that, well, if we can't get your privileged information, you're just going to run everything through an attorney and give us less than we're getting now?
No, I haven't heard it framed that way. I mean, if it's privileged, it is being run through an attorney.
No,
Right?
I guess my question is, what we would normally have done just without attorney involvement now, like we're going to hire a law firm and they're going to be the ones that, run our investigation, or as Brian said, do all our fair lending testing now.
Yeah, I mean, look, I think most sophisticated entities are trying to, even for the fair lending testing, are probably, if they're doing it in-house, are still generally involving in-house counsel or something. Maybe not, and that's okay. It really depends on what the risk reward, what the risk appetite is there. But no, I mean, I think, look, I think at the enforcement level, they're used to having to prepare privilege logs. I think this is just a nuanced argument because the states really are starting to figure out, or I think try to figure out, why certain things are different at the federal level. And I can't say, it's not clear to me that part of that is because you have people who were at the Fed come to states and think things should work the same way and not necessarily understand why there might be reasons they don't.
That's great. Let's leave the state issues for a minute, unless somebody's got some specifics there. I'm deciding whether I want to ask this question or not. I think it's fun. Let's have some fun here for a minute, and then we'll go to maybe something a little more serious. What would you guys do if your client got a repurchase demand for Letitia James's loan? Okay, let's move on to our next topic.
Haven't we all?
Nobody wants.
Haven't we all?
Nobody
I'm
wants.
not even a litigator, and I have had, I think, 2 of those.
That would be interesting. Let's just say. Okay. We did get something in the chat about asking about the Optimal Blue case, which we just saw. Again, nobody should have to speak about something that they're working on unless they know they can. So, Michelle, do you have any insights on the Optimal Blue case
There's
that
lots
you
of
can share?
things. Yeah, there's lots of things people want to talk about that I can't talk about because I'm working on them. We are counsel of record to one of the 26 lenders in the Optimal Blue case, but I'll talk about it big picture, right? I'm not going to talk about arguments. I'm not going to talk about defenses. I'll give you a quick overview and where we think that's relevant. First, for those of you who don't know or aren't aware, a couple weeks ago, case filed, 4 named plaintiffs on behalf of a putative class. The homeowners are in Tennessee, Minnesota, and Delaware, who obtained mortgages from 4 of, again, 26 lenders named in the complaint. In addition to the 26 lenders, Optimal Blue is named, Black Knight as the prior owner and seller, and Constellation as the current owner of Optimal Blue. What I will say first is this, and I've said this too, we've half a dozen clients that are defendants. We represent one of them because, gotta pick one. But it really is an antitrust case. It's less a mortgage case. Of course, it involves mortgage software. It involves allegations involving mortgage pricing. But the case is about antitrust concerns and the sharing of information. And in particular, at a high level, they allege that the defendants, meaning the companies responsible for and the use of Optimal Blue and those lenders, engaged in a nationwide conspiracy to artificially inflate residential mortgage rates and fees by sharing competitively sensitive information, meaning data from locked mortgage loans and other mortgage data collected within the OB environment with competitors, which they claim allows them to coordinate pricing. So the claims come down to really 2 big issues. One is price fixing in violation of Section 1 of the Sherman Act. The second is information exchange in violation of Section 1 of the Sherman Act, which is basically regularly exchanging detailed, timely, and competitive, sensitive, and public information about each other's operations and specifically their pricing through the use of Optimal Blue. Now, let me pause for a second and just flag this for you. 26 lenders, a software solution provider, prior owner and current owner, and they are allowed to seek treble damages and a permanent injunction. So somebody's saying to me, like, what's the exposure here? Like, when you look at that collective group, some of the biggest lenders in the country, it's a pretty significant case on paper from that perspective alone. That said, there's some very keen differences here between some of the other cases that we've seen brought, including in this court. So I do think you will see the facts play out here in a way that perhaps demonstrate that this maybe isn't the same case as some others. But look, what the complaint does is it looks at, published statements from Optimal Blue software marketing materials from a couple of lenders that talks about how, the real-time intelligence within the software has allowed lenders to coordinate pricing, get better at setting margins, and that there is this market dominance in this space, which is part of why you feeds into that anti-competitive behavior. I know there's a, oh my gosh, if I use Optimal Blue, am I in trouble, right? I can't advise anyone specifically on any one thing. I do know, of course, that not all lenders use the software in the same way, and not all lenders use the same features in that way. The complaint calls out some specific features and some specific issues. So it flags, for example, the percentile ranking tools, right? So ranks lenders by volumes, gross profit, average amounts that you can then use to filter LTV, borrower FICO range, and it flags that as, just a way to collect competitive information, rate and price sharing, comparison tools, including direct price coordination. And again, these are allegations in the complaint, right? These are just allegations. And then, of course, margins and concessions tool, which the complaint says allows lenders to monitor on a granular and geographic level how much they are, quote, giving back in concessions. Big picture, it's a theory of, antitrust conduct. It's not new. It's not novel. There's actually been a number of cases with similar allegations. One such case that you've probably all heard about is the RealPage case, which actually goes to revenue management software for apartment and other tenant rentals. It's a very different case for reasons I'm sure will come out in the papers than this case. These cases have also, and I say this because, Brian, Melissa, and I think Peter too, are all hidden in different rooms right now at MBA in Las Vegas. This theory has been tried against actually a number of the casinos here in Las Vegas as it
Interesting.
relates to and not very successfully. Candidly, some of the casinos have been really successful in obtaining dismissals, including in one case involving MGM, which is where we are not, where a court dismissed a Section 1 claim and found that competitors simply using the same software at the same time does not an antitrust conspiracy make. So that is an overview. I think more to come about how folks tackle this case, how we on behalf of our clients tackle it. No advice on what you do with the software, but one thing I will say, and this is not legal advice, this is just practical common sense. There is a question right now about so much of public statements and marketing materials and things like that are present in the complaint. You just don't say things like we've opened up the kimono and gotten all that pricing detail to our clients, which is one of the quotes. Doesn't mean doesn't mean that means anything relevant to the case, but people are going to take things out of context. Or some of the case studies that say, this has helped us improve our margins by blah, 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 because we can see what other people are doing. Look, we all know how highly competitive this market is. The idea that people are actually really sharing information, like, please, right? Everyone's suing each other. No one's sharing stuff. At least is my gut instinct, but it's a really interesting case, especially from a legal perspective. And so I think, we'll all be talking about it for some months to come.
And Michelle, is there any particular reason that the case was brought in federal court in Tennessee? Is there any district or circuit court law that's particularly favorable to the plaintiffs?
Yeah, so that court is actually where that RealPage case that I referenced was filed. So there might be some effort to piggyback off that case. I would say objectively, there's some big differences between the two cases as well. And so, it's always a tactical question when you're filing a complaint of, do those things work for you or against you? And here, I think the plaintiffs thought, they worked in their favor. I'm not sure, that will bear out, but we shall see.
That's great. We only have a couple more minutes, and Michelle, I would love to ask you about another case that you're working on, but I don't think we have time, and I don't think you have the ability to talk about it. I know Loretta's disappointed too.
I know. We didn't want to trick you and say we're going to talk about one thing.
It involves my favorite topic, and that's well, one of my favorite topics was loan officer compensation. I think everyone's aware of that case. We've talked about it here before. So I did want to give Melissa one more chance to talk. And you didn't talk much about your armor role. And I'm going back to the state issues, but if you wouldn't mind, maybe give us a little insight about what that job is.
Sure. Thanks, Brian. So with armor, of course, it's so many long words put together, but think of it as all the state mortgage regulators all coming together, and they have an industry advisory council. And so that's industry members who are members of armor. And we get together to work with the armor board, which is a variety of state regulators. So Kirsten Anderson currently leads that, but you've also got, Cliff from Maryland, we've got Bill from Texas, Kevin from Massachusetts. So there's lots of different representation on the state side as well. So we meet 4 times a year and between the two groups, and then we talk about different topics. So when Michelle was up on stage back in a month or so ago and the privilege topic came up, that, for instance, was one of the things I sent Kirsten a message on and said, I think we need to talk about this. So it's really an aspect of being able to take industry concerns or questions, or also partnering with the state regulators on maybe different things they want to do or they want to find out more about. For instance, AI has been a big one, right? For the state regulators, is to try to get their arms wrapped around, well, what is AI? How is everyone using it? And they really want to learn more, but I think everyone's trying to learn and figure it out and then be able to work together and build some synergies there. So it's just with the IAC and chairing that, it's really an opportunity for me to try to make sure that the industry is represented at the table.
Well, that's great. How do people get in touch with you or get involved if they want to sort of give their input.
Yeah, well, you can email me at my CMG or the RegList email. I'll just give the RegList one since it's probably easier. So it's Melissa at reglist.org. So you can email me about the RegList, you can email me about Armor, you know, whatever other topics that you have. I really try to be a good representation to all the different groups a lot of us are involved in, just to make sure our voice is heard. Anything from, you know, the NMLS being down and not processing to loan officers, to something bigger like the privilege issue that Michelle and her team has brought up and is so timely for what a lot of us are experiencing.
Well, this has been great. Does anybody have anything else that needs to get out? I just want to thank everyone for a great conversation and wish everyone well with the rest of the conference if you're here. And thank you again, and we'll see you again next month. And thanks to our sponsors again, Polunsky, Beitel, and Green. Bye, everyone.
Thanks, everyone.
Bye, thanks.
Good.
Thanks, everyone. All right.
Thanks, everyone.
Bye.
Bye.